Okay, so we're continuing on with 140-160 class, and this now is medical information. It's a doctor's testimony. And I'm just going to kind of read through the questions. They won't be said, and I'll make it be like one long narrative answer.
Clicks aren't working over here.
Check and see if it's plugged in under the desk. Okay, so here we go. Not counted on the record. Now, you're asking me things I don't know. All I know is hearsay, and I can't testify to that. I do know that the next thing that happened was that I was called into the room because the head was out. Now, how it got out, you'll have to ask the other doctors, because I was not a witness to that part of the delivery. I was later, but I did notice there had been shoulder dystocia, and you don't, that's the real hazard of shoulder dystocia, is you really don't diagnose it until it happens. And there are certain things that you kind of look for, if you will, to help you spot it. But, and I suppose the most common one is a condition known as macrosomatia. Macrosomatia. You and I know it as big babies. Macrosomatia of a baby that weighs, say, 4,000 grams. You can expect to get a shoulder dystocia with this somewhere around 4 to 5%. If you go over 4,500 grams, you can expect maybe 10% shoulder dystocias, which gets you then looking at a situation, well, what do I look at? The glass half full or half empty, you know? If I tell you that babies that weigh 4,500 grams or more will have 10% shoulder dystocia, you say, golly, that's pretty significant. And I say to you, it's more significant that 90% won't. Well, but I think what it does do is, if you have that information, it certainly puts a bug in your ear, doesn't it? That you're sort of saying, wow, maybe I got a problem here. Maybe I got something going on. Diabetics usually tend to have big babies. So if somebody is diabetic, you look for big babies. And when you look for big babies, you look for shoulder dystocia. Usually the maternal pelvis is not a problem, because if the maternal pelvis is a problem, you can't get the head out. And that's great for shoulder dystocias, because if you can't get the head out, you can't get the shoulder out. Dysfunctional labor may be a problem in some, but I think your major problem is a macrosomatia problem. You get these little tiny football players coming out. And again, the only information I have that I can testify to at this time is exactly as I testified to. It was reported to me there were no complications in this lady's prenatal course. So my consultation at the time was based on that information, and I haven't really gone back and studied the sonograms and this sort of thing. And I just don't know whether or not the house staff usually does sonography right up there on the floor in addition to whatever is usually done. I don't know if that was done now or at that point, because the only information given to me was again by Dr. Gill that things were okay. And if the birth canal is too small for the head, the chances are you're not going to get a shoulder dystocia, because you can't get a shoulder dystocia until you deliver the head. So if you can't get the head out, you can't get a shoulder dystocia, can you? The answer to that question is yes, there's a way of evaluating the size of the birth canal. It's an estimate, but there's a way of doing that, and this is done routinely as part of the prenatal examination. As far as I know, there was no problem there, and this was part of the information that was imparted to me by Dr. Gill, that there was no problem. And I think you testified, well, I think it's been testified that the biggest concern at the time was that in all my years, I've seen a number of shoulder dystocias, but I've never seen any with central depression like that. And I was just trying to figure out why. And I knew that, that I didn't see where there had been any major trauma to the baby as far as delivery was concerned. It's just in terms of central trauma. We actually just sat there trying to figure out something. We really didn't come to any conclusion at that time. I don't know whether at that time Dr. Lindenberg was considering the possibility of what eventually showed up on the PATH report or not, because we didn't discuss it. We never did. That's why I answered your former question as I did. The diagnosis as far as the baby was concerned, I didn't really have any opinion on the matter until I got the PATH report. I was thinking of that, and I was thinking of trauma afterwards, some sort of systemic disease that the baby had. Maybe the baby was diabetic or some other type of disease. We went through a number of scenarios and none of them really added up. So now I'd have to review the PATH report to answer your question about asphyxiation. Right now, I can't answer that question. I've got the immediate cause of death as cardiopulmonary arrest. And then they say due to severe neonatal asphyxia due to severe shoulder dystocia. So that's what the report says. Okay. That's all we're going to do from that today. And now I'm going to work on some straight matter warm up. Actually, I'm first going to do some jury charge because I feel like I can get faster with the jury charge. So and this will be next week's EV 360 that I'm working on. And let's start with that. On the record, ladies and gentlemen of the jury, it is at this stage of the trial that the court will now give you the law that you must follow during your deliberations. The defendant, Pat O'Shea, has been charged with the death of Taylor Smith. The charge of the court is given to you to provide you with elements of the law that you are to follow during your deliberations. A copy of the court's charge will accompany you in the jury room when you commence your deliberations. Exhibits that were offered and received in evidence by the court will also accompany you in the jury room and should be considered by you, ladies and gentlemen of the jury, during your deliberations. Exhibits that were not received in evidence should not be considered by you. Opening and closing statements of the attorneys should not be considered as evidence in the case. These opening and closing statements were given to you by the attorneys as an overview of what the attorneys expect the evidence to show and what the attorneys would like you to conclude after hearing all the evidence and viewing all the exhibits in the case. Again, opening and closing statements are not evidence. The evidence you are to consider is the testimony received from the witness stand and the exhibits that were received in evidence by the court. Ladies and gentlemen of the jury, you must find that the defendant was aware of and consciously disregarded the risk of causing death. If you find that the defendant was aware of and disregarded the risk of causing death, you must determine whether the risk that she disregarded was substantial and unjustifiable. In doing so, you must consider the nature and purpose of the defendant's conduct and the circumstances known to the defendant, and you must determine whether, in light of those factors, the defendant's disregard of that risk was a gross deviation from the conduct a reasonable person would have observed in the defendant's situation. All of the evidence relevant to recklessness, including any contrasting accounts of events by the defense and the state, must be considered by you. Another element that the state must prove beyond a reasonable doubt is that the defendant acted under circumstances manifesting extreme indifference to human life. The phrase "under circumstances manifesting extreme indifference to human life" does not focus on the defendant's state of mind. but rather on the circumstances under which you find she acted. If, in light of all the evidence, you find that the defendant's conduct resulted in a probability as opposed to a mere possibility of death, then you may find that she acted under circumstances manifesting extreme indifference to human life. On the other hand, if you find her conduct resulted in only a possibility of death, then you must acquit her of aggravated manslaughter and consider the offense of reckless manslaughter, which I will explain to you shortly. How you doing? It's pretty fast. It's okay? Mm-hmm. Okay, let's go on. The final element that the state must prove beyond a reasonable doubt is that the defendant caused Taylor Smith's death. If there is a causal relationship between the defendant's conduct and the result of the conduct is not an issue, you must find that Taylor Smith would not have died but for the defendant's conduct. If causal relationship between the defendant's conduct and result is an issue, you must consider the definition of causation. Causation has a special meaning under the law. To establish causation, the state must prove two elements beyond a reasonable doubt. First, that but for the defendant's conduct, Taylor Smith would not have died. Second, Taylor Smith's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct, and must also not be too remote, too accidental in its occurrence, or too dependent on another's volitional act to have a just bearing on the defendant's liability or on the gravity of her offense. In other words, the state must prove beyond a reasonable doubt that Taylor Smith's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of aggravated manslaughter. Where the defendant and state offer contrasting factual theories of causation, each version should be considered by the jury. If after consideration of all the evidence you are convinced beyond a reasonable doubt that the defendant recklessly caused Taylor Smith's death under the circumstances manifesting extreme indifference to human life, then your verdict should be guilty of aggravated manslaughter. If, however, after consideration of all the evidence you are not convinced beyond a reasonable doubt that the defendant recklessly caused Taylor Smith's death under circumstances manifesting extreme indifference to human life, you must find the defendant not guilty of aggravated manslaughter and go on to consider whether the defendant should be convicted of reckless manslaughter. A person is guilty of reckless manslaughter if he or she recklessly causes the death of another person. In order for you to find the defendant guilty of reckless manslaughter, the state is required to prove each of the following elements beyond a reasonable doubt. 1, that the defendant caused Taylor Smith's death, and 2, that the defendant did so recklessly. One element that the state must prove beyond a reasonable doubt is that the defendant acted recklessly. A person who causes another's death does so recklessly when he or she is aware of and consciously disregards a substantial and unjustifiable risk that death will result from his or her conduct. The risk must be of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to the defendant, his or her disregard of that risk is a gross deviation from the standard of conduct that a reasonable person would follow in the same situation. In other words, you must find that the defendant was aware of and consciously disregarded the risk of causing death. Okay, I'm going to go back and repeat 3 minutes now. This will come right out of the middle. And it'll be a push. On the record. The evidence you are to consider is the testimony received from the witness stand and the exhibits that were received in evidence by the court. Ladies and gentlemen of the jury, you must find that the defendant was aware of and consciously disregarded the risk of causing death. If you find that defendant was aware of and disregarded the risk of causing death, you must determine whether the risk that she disregarded was substantial and unjustifiable. In doing so, you must consider the nature and purpose of the defendant's conduct and the circumstances known to the defendant, and you must determine whether, in light of those factors, the defendant's disregard of that risk was a gross deviation from the conduct a reasonable person would have observed in the defendant's situation. All of the evidence relevant to recklessness, including any contrasting accounts of events by the defense and the state, must be considered by you. Another element that the state must prove beyond a reasonable doubt is that the defendant acted under circumstances manifesting extreme indifference to human life. The phrase "under circumstances manifesting extreme indifference to human life" does not focus on the defendant's state of mind, but rather on the circumstances under which you find she acted. If, in light of all the evidence, you find the defendant's conduct resulted in a probability as opposed to a mere possibility of death, then you may find that she acted under the circumstances manifesting extreme indifference to human life. On the other hand, if you find that her conduct resulted in only a possibility of death, then you must acquit her of aggravated manslaughter and consider the offense of reckless manslaughter, which I will explain to you shortly. The final element that the state must prove beyond a reasonable doubt is that the defendant caused Taylor Smith's death. If there is a causal relationship between the defendant's conduct and the result of the conduct is not an issue, you must find that Taylor Smith would not have died but for the defendant's conduct. If causal relationship between the defendant's conduct and result is an issue, you must consider the definition of causation. Causation has a special meaning under the law. To establish causation, the state must prove two elements beyond a reasonable doubt. First, that but for the defendant's conduct, Taylor Smith would not have died. Second, Taylor Smith's death must have been within the risk of which the defendant was aware. If not, it must involve the same kind of injury or harm as the probable result of the defendant's conduct, and must also not be too remote, too accidental in its occurrence, or too dependent upon another's volitional act to have a just bearing on the defendant's liability or on the gravity of her offense. In other words, the state must prove beyond a reasonable doubt that Taylor Smith's death was not so unexpected or unusual that it would be unjust to find the defendant guilty of aggravated manslaughter. Where the defendant and state offer contrasting factual theories of causation, each version should be considered by the jury. If after consideration of all the evidence you are convinced beyond a reasonable doubt that the defendant recklessly caused Taylor Smith's death under the circumstances manifesting extreme indifference to human life, then your verdict should be guilty of aggravated manslaughter. Okay, that I know was a push. That was 180. Now we're going to slow down and do some straight matter, and then we'll start our straight matter chase after that. Okay, United Nations comes up in here, and there's a brief here. YTNS, United Nations, excuse me.
I'm sorry, you said YT?
YTNS. Okay, here we go. Mr. Speaker, I would like to point out to my colleagues several reasons why the United States of America should no longer support the United Nations. The records will show that the United States of America has picked up the tab for the United Nations for a period far longer than anyone wishes to acknowledge. Our government has supported the UN and its functions and operations for over 40 years. We have overextended ourselves and our hospitality. This organization, which is an international peacekeeping body, has really never done anything for the citizens of the United States of America. American taxpayers are footing the bill. We are paying approximately 30% of the salaries of the employees of the United Nations. None of these salaries are regulated by the U.S. government. Members of the United Nations are some of the highest paid bureaucrats in the world today. As the size of the United Nations continues to grow, so does its budgetary needs. Since its inception, the UN has continued to increase the size of its workforce. The number of agencies and bureaus connected with the United Nations operations has also continued to increase. The United Nations is a far-reaching organization touching mankind around the globe. Originally, the pay scale for all UN employees was designed to match that of the best paid U.S. government civil service employee. The current pay scale is over 20% above that of the best paid American civil service employee in a similar or like position. Some of the flagrant abuses of the United Nations would shock even the most hardened government bureaucrat. The Secretary General of the United Nations lives rent-free. He is provided with a 24-hour limousine and a large staff of office workers who are at his disposal any time of the day or night. He has a staff of household help and also receives an ample travel allowance for himself and his family. Over 30 employees of the United Nations make over $120,000 a year. What is most surprising is that all of the professional employees of the UN receive some additional compensation for foreign service duty along with their regular salary. In recent years, the United States government State Department has made some half-hearted attempts to persuade the UN to hold down its salary scale. This has not worked. Salaries continue to escalate at a faster pace than the rate of inflation. The United Nations has continued to expand in areas that are very costly. They have continued their efforts of relief to children in poverty-stricken areas around the world. This is a very expensive venture, and its services are not closely monitored. The UN continues to serve non-member countries by supplying food and medical aid. This is mainly a peacekeeping tactic and has been ineffective in some areas of the world. The United Nations has appointed advisors to represent developing nations. This has proved to be very costly to both the United Nations and the United States of America. It is my belief, Mr. Speaker, that with all of these projects that the United Nations is pursuing, that they should write their own ticket. The United Nations should no longer be supported by the United States of America. We need to free our citizenry from another tax burden. The United Nations needs to pay its own way. Okay, we're going to start taking notes. So that's it for the warm-up.